there's two warranties in Louisiana law that landlords cannot waive in their lease. So one is the warranty of habitability, which I'll talk about here, and then a little later I'll get into the warranty of peaceable possession. So you cannot, if you're a landlord, put in your lease that the client waives the warranty of habitability or the peaceable possession. If you do that, that's illegal under Louisiana law, and those will be stricken from your lease contract because they're not valid. So this is where the lessor warrants that to the tenant that the thing is suitable for the purpose for which it was leased, and that it is free of vices or defects that prevent its use for that purpose. So if the landlord, knows that there's lead paint, for example, they can't just paint over it and say that it's fine. They have to warrant that it is suitable for people to live in and that it's safe, and they have to make sure that it's free of vices or defects. And then this warranty also extends to vices or defects that arise after the delivery. The delivery is when the tenant moves in. So this is not just for vices and defects that were in the unit prior to the tenant moving in. If anything happens during the tenancy, the lessor would also need to take care of that. As long as they're not attributable to the tenant. The tenant throws a party and their friends destroy a bunch of stuff, even though that might have caused the vices or defects, that would not be on the landlord to fix because the tenant or the tenant's guests caused that. So the warranty of habitability cannot be waived, and then here's the law that would just state that I just already said, just in legal language. The other warranty that cannot be waived is the warranty of peaceable possession. This is where the landlord warrants that the tenant can live there peaceably against any disturbances caused by a person who asserts ownership or the right to possession or any other right in the thing. For example, I had a landlord who had a crush on my client, and he would come to her house on Friday and Saturday nights at 10 p.m. And want to hang out and wouldn't leave. And that's violating her right to enjoy her unit. It's also possibly illegal in other ways, but that the law would protect him from doing that. When you rent to the tenant, it is the landlord's property, but you rented it for them to use to live in with their family, and they should be able to do that peaceably and without anything coming their way. So what happens to the tenant if they lose in court at an eviction hearing? If the landlord wins and the tenant, if the landlord wins, the judge will order the tenant to move out by a certain date or time. The soonest they can do is 24 hours after the court date, but the judge has the discretion, or the parties have the discretion, to work out more time. So usually tenants will ask for more time than 24 hours because it's really hard to pack your stuff, find somewhere to go, even to get a U-Haul and do all that within 24 hours. But sometimes it is 24 hours. So after the court date and you have the judgment of 24 hours, you have 24 hours to vacate. And then if the tenant is still not out, then they must get a warrant for possession from the court, which is where they go to the court and they pay the constable to come out and physically remove the tenant and their items from the property. So even after a landlord has a judgment of eviction, the landlord cannot go in the unit and remove the belongings on their own. They would need to get the constable to do it. And that just protects from any alleged damages by the tenant or the landlord. Sometimes it's just easier to get a third party in there. And also, once you go through the court process, you need to take it all the way through the court process. So the landlord has no duty to store the property or to not put out belongings because of bad weather or anything like that. It's just whatever the time frame is, whatever's going on, it doesn't matter according to the law. Yeah.
I came in a few minutes late. Do you mind taking a couple of questions?
Oh, no.
Okay. Let's say the situation down Range right now. I know the situation where with the flooding, the apartment complex sent out notices to everyone who had flooded on the bottom floor and said you need to have everything out within 48 hours. Your thoughts on that?
Well, my thoughts, first of all, I don't know what their lease says, but if their lease doesn't have a waiver of notice.
Let's say the lease at least provides that in a natural disaster situation that repairs would take over 30 days and the lease would be voided at that time.
Well, I mean, if the lease has protections in it, or the lease has an instruction, then that's what you would follow. It depends on if the units are habitable or not also, because if the unit is still habitable, then the tenant can live there. Once the unit's not habitable or they're not able to live there, then
Is
technically,
48 hours a reasonable time frame?
no, I mean, you still want to give the 5-day notice, and then, there'd still be a court process to go through, but once
You
the,
still have to go through the court process, even though the lease provides that, that if repairs take over 30 days to make it habitable. Because say flood water's well 4 feet, clearly all sheet rock needs to be ripped out, electrical, you're looking at probably a 2 to 3 month process.
and if,
So
yeah.
is that an unreasonable notice? Kind of struck me that 48 hours is unreasonable.
Yeah, no, I mean, it would be, the reason we have, courts is because they might think it's uninhabitable and somebody might not. They might still be able to keep their items there, while still having possession of the unit until they can find something. So we want to go through the court process. The court would most likely, if it is uninhabitable, would terminate the lease and give the 24 hours from that court date. But the tenant would still have the right to go to court and present their defense. And the 48 hours, unless the 5-day notice is waived, they would still be required, to give that notice.
Okay, so at the very least, it should have gone through the procedures.
Yeah.
They didn't have that.
Then that could,
48 hours with those.
and that could possibly be an illegal eviction. And if you do remove the client's items from the property illegally, then you're responsible, if they sue you, you're responsible for the damages of the actual value of the items, plus any other fees that they incur. They have to stay in a hotel, transportation costs, those kinds of things. So if your safest bet is to go through the court process, or to talk to your tenants. Sometimes if it's that bad, the tenants want to move, they just need to figure out what to do with their belongings, and some landlords, can work something out where they have another unit where they can store stuff or something like that. But you still have to go through, you can't avoid the court process. And a lot of landlords try to do that. Like in Orleans Parish, to file an eviction is about $200. To put a notice that you printed off your computer is virtually free. So they try to do that instead of going through the court process to save some money and also some time. But yeah, once you remove those items, if you did that illegally, you could be on the hook for a lot of money, depending on the value of the items and the other damages that that person suffered.
Yeah, thank you. I appreciate
Yeah.
it. It was just an unusual situation because of that.
Yeah, and that definitely, it's always a tough, tough to do that, because sometimes, because it's not like the landlord's trying to necessarily be a bad person and throw stuff out. A lot of times it's, you want to get in and you want to make those repairs before things get worse. You want to, take care of everything so that your units stay habitable. But you also had rented it to a tenant and they must have possession rights. So you got to follow that process.
Amanda? There was also a question about the flip side of that, habitability when someone wants to break the lease and the landlord's saying that they need to provide proof. Say if it's a mold issue, they smell a sickening smell of mold in the apartment, but the landlord says that they need to provide an expert opinion on mold and a doctor's note. So if you could just quickly just say what you think about what you would require to try to break a lease.
Well, so on the other side of that, if the tenant does feel it's uninhabitable, then technically, the lease is broken and they could potentially move out. But if the landlord doesn't agree with that, then they could be responsible for damages for breaking the lease. They could lose their deposit. They could lose, depending on what the lease says, if you move out in the middle of a lease term, you could be responsible for the rest of the lease term. There could be some penalties, that kind of thing. We do recommend going to a doctor, especially for mold and mildew. And also you can get mold test kits at Home Depot for $10. You don't necessarily have to hire a mold expert to go in there, but you would want that documentation. You'd want to take pictures, even if they're on your cell phone. You would want to get that proof, because there's always an argument with mold and mildew that some of it's toxic and some of it's not, and it depends on the situation. Sometimes it could smell mildewy, but there's not actually any sort of health damage to it. So that really depends. But if the tenant wants to break the lease, they could just move out, but if the place was habitable or if the landlord sues for those damages, they could be on the hook for that. So you would want that documentation. And then I'm not going to go too much into the post-judgment actions, but if a tenant is not successful in court, if they had filed a written answer in their eviction, which means they filed something in writing explaining their side of the story, and they still lost the case, then they could file a suspensive appeal. There's 2 types of appeals. You have a suspensive appeal, and then you have a devolutive appeal. A suspensive appeal would suspend the judgment, which would mean while the appeal process is going through, you can stay in the unit. You still have to pay your rent and follow all your other obligations. A devolutive appeal would mean that you have to follow this judgment, but if you win at the appeal level, you have the right to return, plus you could get the damages for the time that you're out of the unit. So all substantive appeals require a bond. Usually the bond is 1 month of rent. If it's somebody who's subsidized, it's usually what their portion of rent would be. You can also file for a motion for a new trial, but for those you would need to, that you disagree with the judge on the facts of the law of the case, or there was some sort of evidence that you could humanly possibly get prior to the case. So for example, if you needed some documentation from the housing authority, and the guy who has the documentation is in a coma and gets out of a coma a day after your hearing, you couldn't have possibly gotten that information or had him come as a witness, and now you can, so you file a motion for retrial in that case. But I don't want to, get too much into that. We can talk about that. Yeah.
I'm sorry.
Oh, you're good.
Backtrack a little bit. I just got questions on the things I've heard going on in Langston where some of the units were almost 7, 8 feet. They're trying, the landlords are trying to get tenants to move on the second floor, where they're claiming that everything's fine, with common sense dictates not. Then how do we try to work with somebody on that? Normally you're going to want to cut, rock basically twice as high is what the damage is. They're trying to move people to places that 2 or 3 feet above after they put water damage. That would be possibly received now.
So you're saying like the first floor was damaged?
First floor was almost completely underwater. They're trying to pull people at least move to the second floor units.
I guess that would depend on the structure and how safe that is. I'm not an expert on construction stuff, but if the first floor is pretty damaged, then I think that would threaten all the other floors above that. And there's also mold and mildew and creatures and other things but if you're in a first floor unit, you lease that unit. You haven't leased any other unit. So if you want to go lease another unit, you'd actually need to enter into a new lease agreement anyway. So that would be up to the tenant if they want to do that. I mean, I wouldn't want to do that. But if the landlord, you have to look at their lease to see what the landlord would need to do. And then also what the tenant needs to do. I'm sure a lot of tenants on the bottom floor want to move. They can't force them to move to another unit that they haven't contracted for. And then I just wanted to point out some fair housing time here. Yeah, I'm good on time. I was going to talk about some fair housing basics, and then I was going to mention the Louisiana Violence Against Women Act that was passed recently. So fair housing basics, housing discrimination is illegal. The Fair Housing Act was enacted in 1968, an amendment in 1988 to cover persons with disabilities and persons with children. There's 7 different protected classes under the Fair Housing Act that you can't discriminate in housing, including sale, rental, mortgage lending, advertising. So you can't advertise a place and say, great place, you don't want children. That's illegal because you can't discriminate based on familial status. You can't discriminate based on race, disability, national origin, religion, sex, race, color, national origin, religion, sex, disability. Disability was added on the first one. But there are protected classes, so you can't see somebody and not rent to them because they're a woman or because of the color of their skin. So you just want to keep that in mind. And then there's some local laws might also have additional limitations, like you can't discriminate against elderly folks or folks of a certain sexual orientation. These are all the laws that you can find this at, and like I said, I'd be happy to provide this, and these are the federal laws with the Fair Housing Protection. So landlords cannot refuse to rent the property to a person with a business membership in a protected class. Like I said, you can't refuse to rent to someone because they're a woman or because they have children. And then you can't discriminate in the terms, conditions, or privileges of the rental. So if you have a fourplex and 3 of the tenants are men and 1's a woman, you can't have different lease terms for the woman than you can for the men. You can't discriminate in advertising, which I gave you the example of, and you can't misrepresent the availability of housing. So you can't meet a person and you see it's someone who's African American and say, oh, this unit's not available, and then someone who's Caucasian shows up an hour later and gets the unit. That would be discrimination. And if you are a tenant who thinks you've been discriminated against, or if you're anybody who thinks you've been discriminated against, the Greater New Orleans Fair Housing Action Center, which despite their name actually covers the state of Louisiana, they would be the ones you would go to for that. So landlords cannot refuse to accommodate people with disabilities by not allowing them to make reasonable modifications to housing. So if you have a tenant, for example, who's in a wheelchair, and they want to build a ramp so that they can access their house, that would be a reasonable modification, and you can't, you have to allow them to do that. You don't necessarily have to pay for it, but you have to allow that modification. That's the most common ones we see sometimes. It's like a bar in the shower to help somebody stand up. I had a client who was deaf, so she had a doorbell that was installed that would blink, so she could tell when someone was at her door. And those are modifications to help someone who has a disability access their unit the same as everybody else. And then landlords cannot coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of a fair housing right, or any person who's aided or encouraged by any other person in the exercise or enjoyment of a fair housing right. All right, and then Louisiana Violence Against Women Act for Senate Bill 174 became law August 1st, 2015. Under this law, anyone in need of emergency assistance can contact the police without penalty. Some leases that we've seen say that if the cops come to your property and you've violated your lease, that you could be evicted for that, even if you were the victim of a crime, so that's making that illegal. Just having the cops, you should be able to feel safe enough if you are feeling unsafe to call the police and have the police come help you. And so you can't call the police, have them come out, help you out of a domestic violence situation, and then you're being evicted because you called the police. And that's actually more common than I thought it would be. Survivors of domestic violence can no longer be evicted because of the violence of their abuser. The abuser can be removed from the property and can be removed from the lease, but you cannot then make a domestic violence survivor homeless because they're a victim of domestic violence. Survivors can no longer be denied housing solely on the basis of past abuse. So if they're looking at rental history and they're seeing maybe something pops up with an eviction, or you can search the criminal records and see that they're listed as having a restraining order against someone or something like that, you can't basically deny them housing on that. And then survivors can now terminate a lease early and move if they need to. We've actually in the past had a lot of clients come to us that were 6 months into a lease. They had someone stalking them, they had someone attack them in their unit, they had a restraining order, the accident worked, the guy went to jail, got out of jail, and continued to harass them. And they came to the landlord and said, I can't, he knows where I live, he's gonna keep coming after me. And the landlord says, you got 6 more months on your lease, I'm sorry. And then that person would sometimes just move out of fear, and then they might owe the landlord damages for that. So this now, under LAVAWA, the survivors can terminate the lease early, showing, usually you would need to show proper documentation, either a temporary restraining order, an actual restraining order, or some sort of filing, to show that a police report, anything to show that you are a victim and a survivor, and then you'd be able to terminate your lease without any penalties. And where can you learn more? One of the great things that our office and a lot of other nonprofits across the state do is LouisianaLawHelp.org. It's public information. Our office maintains it, but everyone contributes to it. It's for the public. There's a lot of great, it's not just housing, it's any sort of civil legal aid. So family law, tax, foreclosure, public benefits, FEMA issues. So you can go on there and there's a lot of great forms. I actually helped a client do a pro se divorce using the forms, and I don't know anything about family law, so it's very helpful. If you have someone in subsidized housing, HUD.gov is where you'll go to. If you're a landlord and you rent to someone with Section 8, or you have a tax credit, or you have a project-based voucher, that's a good resource for that. The National Housing Law Project, they're usually on the forefront of all the housing issues, and they have a lot of good resources and presentations to help explain all the things I'm telling you in greater detail. And then this website here is through Loyola Law School. They have the Louisiana Legal Services Desk Manual, and that's where my office and other offices put together a manual kind of outlining the work we do with cases that have happened in Louisiana in the past to kind of coincide with the laws, so that you can see how the laws have actually worked out in court before. And this is my contact information. I'll stick around if y'all have any other questions. But yeah, that's it for me, and I hope this was a good, brief overview of housing law in Louisiana.
Just repeat the question.
Okay, yeah.
You might have to read it here.
Okay, do we have any questions?
Okay, so in the flooding situation we just had recently, are you saying that obviously they've been flooded 3 or 4 feet, the place is uninhabitable, that the tenant can just walk away?
Yeah, if it's uninhabitable and it's not fit for human use,
Even though the landlord is working post days, you know, within a month or 2 months, in better condition than it was before?
yeah, basically, because the landlord has to guarantee that it's fit for human use, and as long as that wasn't caused by the tenant, which it wasn't in this case, they call it an act of God, would be a flood, hurricane, anything like that. And it is unfortunate, especially for landlords that are stepping in and trying to take care of things really quickly, but in the meantime, that tenant can't live there because it's not fit. If the tenant chooses to move back in or to return, they can work out, a new lease agreement or to extend that lease agreement.
What if the landlord provides other suitable housing?
If the tenant chooses that suitable housing, then that would be fine.
The tenant's option.
Yeah, at that point, once it's deemed uninhabitable, and if it did totally flood, it's most likely uninhabitable. At least for the temporary time.
In that instance, with the tenant, you owe her deposit.
So I didn't go at all into deposits, and I'd be happy to talk more about that with you, but the way deposits work is after the tenant moves out, the landlord has 30 days to return the deposit, or to put something in writing explaining why they're not returning it. The tenant should provide a forwarding address, where the check or the letter can be sent to. It doesn't have to be where you move to as a tenant, it just has to be an address where you can receive mail.
But I'm talking about in the instance of a flood, you still have to pay that tenant a deposit back.
As long as there weren't any other damages, then the tenant, as long as there weren't any damages caused by the tenant, then they should be able to recover their full deposit, but the landlord still has 30 days after they move out to return it or to provide in writing why not. And if the landlord doesn't return it in that time, then you can file a small claims lawsuit to request that deposit. There's also another law in Louisiana that if the tenant sends a written demand letter to the landlord requesting the deposit, the landlord has 30 days from receipt of that letter to respond in writing, to either return the deposit or to explain why not. And if they don't, then the tenant, if they sue in court, can get an extra $200 statutory penalty on top of that. So that's to encourage the landlords to release right back and try to work something out.
The exact opposite situation, I was talking about, basically the landlord saying everything has to be moved in 48 hours, which is not reasonable, especially when they have 50 apartments or
Yeah.
something. The opposite situation, act of God, clearly not habitable, clearly, gonna take a long time, and the tenant doesn't move anything out, refuses to move it, cuts off electricity, and now it creates a lot of additional damage if it's, that wouldn't have the tenant do it.
Yeah, and that, then the landlord could retain the deposit. You still have to go through the court process for that. And then if there are damages that are beyond the deposit, then the landlord still required within 30 days of when the tenant does move out, whether it's by eviction or by choice, to still put something in writing. And if you don't have a forwarding address for the tenant, they can just mail it to the last known address, which would most likely be the address of the apartment. Do you have any other questions?
That domestic violence, while there are limits on the size of the rental units, I think it's under a certain amount of units, it doesn't apply.
Yeah, I believe, is it 4? 5. 4 or 5. Yeah, it's either 4 or 5 units. If it's below that, then it's not applied to that. Thank you. I have a friend that was mentioned after the flood, the landlord decided to put locks to it, and their social security Can you repeat that? Oh, yeah. So the question was, your friend was living in an apartment, and after the flood happened, the landlord put locks on the door, took her social security number, and tried to make a payment with it. What should she do is the question.
Call my law.
There's a lot of illegal things happening. There's possible, that's criminal as far as the Social Security, when you're taking somebody's identity, that's identity theft. As far as the landlord putting locks on the door, that's an illegal lockout. If a landlord puts a lock on a door, but you still have the right of possession, you can still enter the unit. So if she has a key to the back door or something, she still has a right to go to the property. She can also technically break into her own place.
As long as she doesn't damage.
Yeah, but if the caveat is if she, let's say she breaks a window to get in, she's responsible for the damage to that window. I one time helped a client, I held a ladder while he climbed in a second-story window. And I called the police, they don't get involved, they say it's a civil matter, but the cop was nice enough to stand outside while we did this.
Okay.
So it's a lawyer holding a ladder in full suit with a cop standing outside while my client's climbing. He was diabetic and his medication was inside, and we changed the lock, so we had kind of an emergency situation created where we had to get access to that. But that was all perfectly legal, even though everything about that sounds really illegal. You might want to talk to the Attorney General or the other law firms about the identity theft, because there's a lot of issues there. Also, the illegal lockout, if your friend suffered damages, if she's had to pay for a hotel, if any of her stuff was damaged, if it needed medicine that's not there and it caused her problems, then that landlord could be responsible for those damages. Yeah, fraudulent FEMA claim, they'll come after you for that. They will. So I don't know what that landlord's thinking, but good luck.
To add on to that, there is an OIG disaster fraud hotline. So any instances like that should go to that phone number, OIG DHS, investigates anything like that. And it's actually 1-866-720-5721. It's 1-866-720-5721.
Any other questions? All right, thank you.
All right. Mm-hmm. Good afternoon, everybody. Rainey, I may draft you to post it up there, and feel free to jump in if I leave something out. My name is Laura Tuggle. I'm the director at Southeast Louisiana Legal Services, and we're the largest nonprofit law firm in the state of Louisiana. We provide free civil legal assistance services to low-income people and other vulnerable people. We may have different kinds of income guidelines. And we have 6 offices, as Amanda mentioned earlier. And our second largest office is here in Baton Rouge. We also have an office in Hammond. And both offices were kind of smack dab in the middle of all the parishes that got impacted by the recent disaster. And our Hammond area also got hit back in March. So some of those folks got hit twice. A lot of us in the room were around during multiple disasters, and so unfortunately, we've become fairly conversant. I do not think I would go so far as to say experts, but we have more experience than a lot of legal services programs in dealing with disaster law, because in the last 11 years, we've had Katrina, Rita, Gustav, Ike, Isaac, and then thrown in there, we had the BP oil spill and the foreclosure crisis. So we've had a lot of challenging situations over the past number of years, and I don't think any of us here ever really thought that we would be in a position where the New Orleans folks would be talking to Baton Rouge folks about flooding in FEMA. So it's kind of odd how things have have really turned out. So we're going to try in the next hour or so to give a very brief and broad overview about FEMA programs and some other disaster law programs. And this presentation was updated to add some of the some very basic information about some of the new housing programs that are getting rolled out, including the shelter at home program, which is not a FEMA program, and some of the other housing programs through FEMA. So what is the trigger for potential assistance through FEMA? It's when there's a presidential disaster declaration of a major disaster. And that is definitely the situation that we are in now. And this type of assistance supplements other state resources and voluntary resources. So really the first line of defense are things like, trying to get to your own resources you may have, or sometimes there may be some Red Cross shelters that are activated, although most of those are trying to close down, and other types of charitable relief. There's a citation here to the Robert T. Stafford Disaster Relief Act. That's the federal law that the FEMA programs come from. And if you were to go on FEMA's website, they do a pretty good job of updating a lot of new alerts and new programs that may be coming available. And they seem to have made a lot of progress in the last 10 years or so with making that program more up to date, and you can now track your disaster registration through an app if you're a technology inclined person. The civil legal aid community is also now in a bit better position than a number of years ago to provide resources to really anyone. So now there's this National Disaster Legal Aid Resource Center. And so it's maintained by actually folks out of Texas, and they collect all kinds of information regarding disasters really throughout the country. So if you go on there, you'll see stuff about like wildfires in, I don't know, where they have wildfires. Where is that? Thank you. California. See, California doesn't have everything great, you see. And there is a tab for Louisiana and the August 26th flooding. And so we try to send information there too, because, even though there are buddies there in Texas, they are not living it and breathing it like we are every day. So we try to send them alerts as they come out. Here's some other things that folks might want to take a look at or keep up with. As I mentioned, you can look at FEMA's website. The governor's office website is actually pretty good. And then there's the FEMA helpline that you can sort of check on things and see how they're going. Right now, I think the last numbers I looked at, we're up to almost 144,000 FEMA registrations for this disaster. The current deadline for applications is October 13th. That may get extended, but that is the deadline the last time I checked to register for FEMA assistance. When you do register for FEMA assistance, there's a lot of information you're going to want to have at your disposal. I'm not going to go through all this stuff because everybody can read this, and so many people have already applied. But if you do call someone, or if you're helping someone call FEMA to find an update, you're going to want to have some basic information. And because of Privacy Act laws, you're going to need to, you can't just call FEMA on behalf of somebody else unless you have a special release. We do have a FEMA approved release that we've used in prior disasters that we just updated for this disaster. And all of the information from today will be sending to the Louisiana State Bar Association, has a disaster relief page. And all of this stuff will be posted there. It will also be posted on our website and on that National Disaster Legal Aid website. So if you're a volunteer attorney, or maybe you're trying to help a church member, or maybe you're a law student or whatever, and you're trying to help someone, you can give permission, but it's sometimes a little tricky. Now, sometimes we also or just do like a three-way call on the telephone. and that often will also work. And then while the FEMA disaster recovery centers are open, there's now about 21 or something like that open throughout the impacted parishes. And that is another place where somebody can go to have a face-to-face, because FEMA, you know, they go where the disaster is. So they really don't have long-term physical offices like, you know, walking into a set office. So they open up these temporary offices, and that's where you can have a face-to-face. But after a short period of time, those places will shut down. And so then you'll have to resort to, you know, the 1-800 numbers and dealing with stuff by faxes. So whenever a major disaster is declared, FEMA will decide, they will often, usually, I think always, start something called the IHP program, the Individuals and Households Program. There are various components of that program. It is open to both renters and homeowners. There's housing assistance, although the types of assistance sometimes depend on if you're a homeowner or a renter. There's also O&A, or other needs assistance. We're going to go through like what some of that stuff is. There's a total monetary limit per household. Last time we checked, last fall, it was up to $33,000, but I have to tell you, I don't know anyone in the world, in my world, who has ever received $33,000 from FEMA. It's usually what we have seen is more in the range of $8,000 to $10,000, although it could be more, but that is often the range that we'll see the folks that we help, their assistance come in at. I wanted to mention this because, as I mentioned earlier, we have had a lot of different disasters over a short period of time here in Louisiana. So sometimes the person you're helping, or maybe it's yourself or a relative, they may have received some assistance from FEMA in a prior disaster. And sometimes, like particularly from Katrina, we are still seeing the possibility of folks being asked to repay FEMA for money that they don't think they were entitled to. So we're still actually getting some cases like that from like almost 10 years ago. So under the current law, if there's a debt, it shouldn't be offset against possible recovery here. So if something like that happens, you might want to call from some assistance. There is assistance. Southern is providing some disaster law assistance. Our office is also providing that type of assistance in the parishes we serve. And our partners at the Baton Rouge Bar Association's volunteer lawyer program are also providing assistance in a variety of disaster-related issues. So a lot of times folks are a little bit shocked to find out that FEMA does not equal insurance. It's not the same thing. So FEMA is really kind of designed to try to help people get to some sort of a minimum standard of living. You know, it's not replacement value. It's not to replace everything you owned or anything like that. It's really basic assistance. So what are some of the basic requirements in order to potentially qualify for some IHP assistance through FEMA? It had to have been your primary residence. So if it was your rental property and you're the landlord, no, probably cannot. There may be some other program that might be able to help you, but it's not going to be the Individuals and Household Assistance Program. If it's your fishing camp or your vacation home, no, the FEMA program is not going to be able to assist you. The place has to have been destroyed, be inaccessible, or be uninhabitable. So both of those conditions have to be met. If you were somebody who was homeless at the time of the storm, you're most likely not going to be able to get IHP, but sometimes other programs roll out that may be able to help homeless people with some short-term or even longer-term housing assistance. So this other thing, even though it is from the Stafford Act, I don't know that I've ever seen this either. So rental assistance. Well, this paper says that it's renewable for up to 18 months. I've never seen anybody get 18 months of FEMA rental assistance, but there, you know, it is in the statute. So, you know, a lot of times in disasters that aren't as catastrophic as this one, you know, you may see more minor flooding, somebody getting a couple of months of rental assistance, and then thinking that homeowners are trying to get back to their pre-disaster dwelling. If it's not quite ready yet, they may be able to get additional time pretty easily. Renters sometimes have a little bit tougher time because the idea is you can go out and you can rent another place. Now, in a major disaster like this, it's a little different, but oftentimes you will, the person that has the short-term rental assistance, they're probably going to have to go through some kind of recertification period, which right now we're not there yet, but that may be also something that people need help with, just submitting the paperwork and figuring out what they need to submit. So if you get rental assistance, or if you're working with somebody that's getting rental assistance from FEMA, anybody want to take a guess what you're supposed to use that money for? How about you, sir? Exactly. Sometimes people don't do that. So you may wind up with some kind of potential recoupment claim or something like that. So you definitely want to use whatever assistance you get from FEMA. You want to use it for that thing. And guess what else you want to do? Lady with the pretty purple, what is that? That black bow. What else do you think you want to do?
Be prudent.
Be prudent and keep your proof. Keep the records. That is right. You want to keep the records for, I don't know, but I would say you want to keep them for a period of time. So, not to endorse any particular product. Our office works with a technology firm out of California, and they helped produce an app called Legal Proof. It's a free download, and the idea is you need to take photos of stuff, and it'll give you a date, time stamp on where you are. It'll document where it is. If you're worried you're going to lose documents, maybe you're moving around, maybe you're not stable, maybe you're in a hotel, maybe you're in a trailer, whatever, and you just want to know that your documents are secure somewhere, you can, I don't know exactly how you do it because I'm not a tech person, but somehow they go up in the cloud, whatever that is, stays up there until FEMA may come a couple years later and say, hey, we want to know what you did with whatever, and then you pull it out of the cloud and say, bam, here it is, theoretically.
Probably.
Theoretically, probably. I'm not sure, I just know that it's a thing, and if you want to look at it, take a look at it. Okay, so what other kinds of housing assistance sometimes get deployed after a disaster? Temporary shelter in hotels or motels, mobile homes, not the old FEMA trailers, but in this disaster, they're a different type of product. Sometimes FEMA even uses boats or military bases. After Katrina, there were these big cruise ships downtown New Orleans where all the sewage and water board workers were living on the cruise ships. And so all kinds of different things happen in a disaster depending upon the magnitude. Other types of housing assistance, if you are a homeowner, you may be able to get some funds to help you repair your damaged home, but your primary residence, not rental property. You may be able to get a little money to help you do some hazard mitigation. You might need to lift your central air unit off the ground, so that it doesn't get flooded. This gentleman right here is going to ask something.
On that subject, let's say that you're a homeowner and because you wanted to start drying it out fast, you hired a crew for $5,000 to get out of the place, and your insurance company says, we're not paying that, we're only paying $3,000. Could you have claimed the $2,000?
may be. I think you might want to try to look at the insurance thing first. But potentially, I mean, sometimes if you're underinsured, sometimes FEMA can assist, but you probably need to try to address it with your insurance company. And unfortunately, I don't know squat about insurance. But our private attorney partners that are doing a lot of volunteer work in this disaster often know way more than I ever would about insurance.
Laura?
Yes, sir.
There was a quick question about primary residence and a clarification. There was a woman who had flooding in March, not from this disaster. She was out of the property, paying rent for the property, staying with family, and then it flooded again due to this.
Yep.
And she was denied to FEMA because it said it wasn't her primary residence.
I would have her call us. That number is, I don't know where she lives,
It's just done.
but shoot my email address in there. We'll see what we might be able to do. So this disaster, it doesn't have a little catchy lady or man's name. FEMA's disaster recovery number is DR 4277. That's it. Forget what the one was back in March. So there's a couple of other things that are coming out in this disaster that are a little bit that I haven't really seen as much before. So there's this other program. We talked about the hotel program and a little bit about rental assistance, but there's a multifamily lease and repair program, the MFLRP program. And so it is a program where actually folks apply for that who are landlords, are property owners. And if the property was not occupied before the disaster, but it could be quickly brought back into commerce, whatever that means, that homeowner might be able to get some assistance under certain conditions if they're willing to rent those units to people impacted by the disaster. And it has to be able to be repaired pretty quickly and 5 or more units. So this is a program that I haven't really seen before, so I'm not sure how this one is going to end up working. But if anyone you know is interested, or maybe they're a small property owner or a small landlord, the phone number they can call is 1-225-382-1464, and they can also go online and check that out. And there will be some efforts to try to match people through FEMA's assistance programs, people that need housing with potential available housing. There's also the yes, sir.
So single-family residences don't qualify for that?
That's my understanding, they do not. They have to have 5 or more units. Someone in the way back.
Live with someone else, or you end up spending money, and you get housing assistance, or you then going to be asked if that money is possible.
So if you're, let's take my situation. So after Katrina, for 6 months, I had to go stay with my mama in my old bedroom. Really weird. But because I was looking at all this stuff, I said, okay, I'm going to give my mom the rent, and we signed this little agreement, and, you know, so it would be good to get something like that. We went and got a receipt book, and, you know, I gave her a certain amount to help with the expenses in connection with that. So it's probably a really good idea to document that kind of thing, just in case. I thought you were going with a different question, but we're going to get to that other thing. Yes, sir.
Good evening.
Good evening.
What is the definition of occupancy?
That is your primary home that you live in? Okay, now, we may have to talk after. I think this is going to be an after situation. But you can ask me. Go ahead. It sounded like it's going to get long.
No,
Go ahead, sir.
I purchased a home on August 11th.
Oh, boy. Jeez.
How far? Cash money.
Wow.
So,
For you to move into? To be your home?
yeah,
Got it.
so I did move there,
Yeah, right.
So, we all had to get on out.
Yep.
Yeah.
Yes, sir.
All across, I mean. So, I'm not gonna tell you what all the person that did it, under some odd $1,000. Yeah.
Right.
At any rate, FEMA came and denied the claim because of the word occupancy.
You know what? I felt like this was going to be a after the meeting question from the moment I laid eyes on you. So why don't we talk? Can we talk after? Is that good? Okay. So I'm glad you're here, and we're going to talk after this. Okay. So the MHU program. This is the mobile home program. Mobile homes may be available for people up to 18 months. There's a real lack of housing, especially rental housing, especially in rural areas, or some people may want the trailer in their yard or something like that. You cannot always necessarily put a trailer wherever I'm not mobile home, get away from the trailer word. You cannot necessarily put a mobile home anywhere you want to. There are zoning restrictions against where you can have mobile homes. Sometimes they end up getting waived or relaxed for a period of time after a disaster. And it really depends on the individual parish, what's going to happen in terms of any kind of zoning restrictions. And so as a last resort, I think FEMA is potentially looking at a commercial site, but they're really exploring other options to try to get folks into housing, hopefully into bricks and mortar housing as quickly as possible. So these are some of the basic criteria: that the property damage has to have been at least $17,000 or more in order to potentially be eligible for a mobile home, or if you're a renter, that your home has to have been destroyed. And so I have to say this because making it clear that these are not the same kind of trailers that were used after Katrina that had a lot of issues with formaldehyde or maybe some other kinds of issues. So I want to talk for a moment here about the Shelter at Home program. This is not a FEMA program. It has a separate application process. Don't know the closing date for this, but it opened on August 29th. In the first week, they got close to 6,000 applications, so a lot of applications. So you can't get to this through FEMA or through a Small Business Administration registration. It is separate. You can go online to shelterathome.la.gov, or you can call this number, 1-800-927-0216. And when you look at the application, it seems to indicate, second or third question, ask about whether you can prove you own it. And the reason why we're seeking some clarification on exactly what is going to be required for that, but when you're starting to get into either FEMA benefits or your own insurance proceeds sometimes, or making a loan, or potentially the Shelter at Home program, or if there's any type of big recovery program that the state rolls out, if you are living in, you're going to have to prove you own it. And if you are living in heir property, like somebody passed away and you've never gone through the legal process to open succession, you're going to most likely have to do that unless there's some kind of special restrictions. Now, it's a little easier to do it now and a little less expensive than it was a few years ago. But in general, it is usually a requirement to access disaster recovery programs. So there is somebody that's going to come talk in a few minutes about that, if I could ever manage to make my way through this stuff. So for this particular program, the flood waters cannot have exceeded 2 feet above the floor of the main living area. There may be exceptions made on a case-by-case basis. So far, that's all the information I have on that yet. It's such a new program that we haven't yet seen folks coming through with a denial, or that we might want to make an exception and say, oh, it's just 2.1 inches, or whatever the exception might end up being. Oh, it's only $15,500. And the limit is 15,000. We really don't know what that may look like yet. So there's potentially sometimes there's other types of disaster relief that come available after a major disaster. And so right now, if someone is a homeowner and they have a HUD-backed FHA mortgage, there is a 90-day mortgage moratorium if you're in a disaster zone, a declared disaster zone. A moratorium doesn't mean you don't have to pay. It just means you don't have to pay right now. I know, a shock. So, I mean, it is. And so a lot of times folks aren't really quite clear that it all may come due in a very short time. So there's on HUD's website, there is a notice that gives you a little more information about that. Now, occasionally after a major disaster, sometimes housing authorities through HUD will announce a program called Disaster Housing Assistance, or DHAP. That hasn't happened yet in this disaster. I don't know if it's going to happen yet. We're trying to monitor that to see if that is going to be something that happens. So right now, if you're someone or if you're working with someone that maybe they live in an elderly complex that was HUD assisted, or maybe they were on a Section 8 voucher, or maybe they lived in public housing somewhere, technically, even though they were in HUD program right now, they could apply for FEMA rental assistance while they're waiting to see what happens with the other program. Now, if they have a voucher, theoretically, they can just get that voucher reissued, but there's very little housing available. So when a major disaster happens, housing authorities sort of work together, and people can transfer or port their vouchers from one jurisdiction to another. Theoretically, you can take your housing voucher and move to Hawaii with it. But that is also something I've never seen work in many, many years. But, you know, you could potentially transfer to Mississippi if you have family in Mississippi, or wherever you might want to go, if that's the closest you can find. So we're going to switch and talk about, we're not going to switch yet. Marla has a question.
The other needs assistance,
Yes.
does that come towards the $33,000 cap?
Yes. Yes. So the other needs assistance is, examples are here. Medical and dental costs. What? I remember after Katrina, we had some folks that had their teeth on their false teeth, very expensive dentures, on a nightstand. Yes, this gentleman, he may have had this happen. No, he's just commiserating. He's just commiserating. But you may have had your dentures on a nightstand, and maybe they literally floated away. You had a Cajun Navy. They had to come and get you and your family out of your house and take you out of your subdivision. So, no telling what you left behind, medicine, whatever. So potentially, you can get medical costs. You may have left medical equipment, heavily medical equipment behind, all kind of different things. We did have 13 deaths as a result of this disaster. So if someone lost their life in the disaster, you can request assistance with funeral and burial expenses. The main one that we see all the time is, all my stuff got ruined. I lost all my clothes. I lost my refrigerator, my appliances. It was, floating, turned over. Lost my tools for my job. I lost my books for my classes, whatever the situation may be. This is the one we see the most. And a lot of times folks get assistance through that. Cleaning and sanitizing property. I mean, they usually give you a nominal amount for something like that, cleaning supplies. Vehicles damaged by the disaster. Now, this one's a little tricky because an awful lot of cars got flooded out. So sometimes folks can get help to help replace a vehicle, but it's really kind of pretty tricky to have that. And then sometimes FEMA will help pay for a moving and storage cost. Yes, sir.
Let's say that you or someone that you hired overworked themselves and got like heat stroke and had to go to the urgent care because of the contract that they have for insurance, their insurance company is saying, no, we're not gonna pay for that. Is that something that we